The court's goal was racial equality. Its decisions have sought to eliminate segregation in virtually every area of life. It has ended the poll tax, which had been widely used to limit black voting. It has ruled against the drawing of political districts along racial lines. It has sought to prohibit all racial discrimination, both private and public, in the sale or rental of property. But its power to achieve full racial equality is limited by the willingness of the nation to comply. Thus, after 16 years, the court's goal remains unfulfilled. Once the court had addressed itself to equality of law for black and white citizens alike, its next task was to secure equal rights for the citizens of our cities. By 1962, critics felt that legislatures were grossly malapportioned in favor of rural areas. In a series of unprecedented decisions, the court said that federal and state legislative districts must be apportioned equally according to population. One man, one vote. The court had ventured into what had been regarded as the domain of Congress and state legislatures. Arthur Goldberg was Associate Justice of the court at that time.
It took a lot of judicial courage to cross that bridge, because the tradition had been that this was not a judicial matter. I was on the court when those cases were decided. It seemed to me, as it seemed to the chief and a majority of the court, that we could not justify that kind of decision. What can be more important in a democratic society than a man's vote? This is what our democratic society depends upon.
In the first reapportionment decision, Baker versus Carr, the court said it had the right to evaluate apportionment of state legislatures. In a subsequent decision, Reynolds versus Sims, the Chief Justice said, "Legislators are elected by voters, not farms or cities or economic interests. As long as ours is a representative form of government, and our legislatures are those instruments of government, elected directly by and directly representative of the people, the right to elect legislators in a free and unimpaired fashion is a bedrock of our political system." The court's decisions were implemented with a minimum of delay and drastically changed the makeup of election districts across the country. In Connecticut, for example, before reapportionment, the town of Union, with a population of 383, and the city of Hartford, with a population of 162,000, had 2 representatives each in the State House. The new districts gave Hartford 10 seats and reduced Union to part of 1 seat. But the court discovered there was a problem in determining fair districts. Yale law professor Alexander Bickel.
If you don't somehow evolve some principle that explains what a fair district is and that enables the court to require the formation of fair districts and to prevent the formation of unfair districts, if you don't do that, it is quite apparent to me, and I think it'll soon be apparent to everyone, that to have simply said one man, one vote, districts must be equal, is to have said something at best trivial, something that has at best some symbolic significance, but which is in practice, in affecting the structure and operations of government, trivial, unimportant. Indeed, there is some evidence that it may be worse than that.
Even if a state is apportioned on the basis of equal population, you can still have political inequality. Here is how gerrymandering may be accomplished. Party A's strength is centered in the western third of the state, but statewide they are outnumbered by Party B. By the criteria of equal population only, A could end up with no representation, as in this example, or with 1 seat out of 3, depending upon which party was drawing the new lines. Professor Bickel feels the decision may make it easier to gerrymander in the future.
That a legislature that is told that it has to apportion on a perfect one-man, one-vote basis and is to disregard all other traditional indicia of apportionment, like county lines or what have you, that such a legislature is thereby freed, in a sense, more free than it would have been if it weren't under the one-man, one-vote mandate. Freed, in a certain sense, to gerrymander in accordance with partisan political objectives.
All states now have reapportioned their legislatures. In this sense, it has been a great victory for the court, but many thought that the decisions might revitalize our political system, might save our crumbling cities. While there is some evidence that more urban-oriented legislation was passed by the new state houses, for most states, it is business as usual. Gerrymandering continues to be an effective weapon to maintain the status quo, and the court has declined to rule on this practice.
A panel of federal judges in Texas is ordering the state of Texas to redraw the state's congressional district map because it intentionally discriminated against Hispanic voters. The judges ruled Friday that in 2011, Republican state legislators engaged in racial gerrymandering by diluting Hispanic voting strength in 2 Republican-held districts and by packing Hispanic voters into a neighboring district. The ruling in another pending case over Texas's strict photo voter ID law raised questions about how the Justice Department and Supreme Court will handle voting rights. Joining me now to discuss that is reporter Reid Wilson from The Hill. So explain what happened in these 2 districts.
There's this term called packing and cracking, and essentially what the court said that the Texas legislature did was they packed Hispanic voters into one district that's centered around Austin, and they cracked those voters apart in different communities. They divided similar communities in another district on the east coast of Texas and a third district that runs along the Texas-Mexico border.
But first, this term, the U.S. Supreme Court was asked to weigh in on one long-running political debate. As Amna Nawaz explains, it's all about what is and isn't allowed when lawmakers draw electoral districts.
Over the past year, the Supreme Court, in more than one case, has tackled gerrymandering. Today, the court ruled on a case out of Texas questioning whether the state used racial discrimination when drawing 4 state district lines. The National Law Journal's Marcia Coyle joins me at the table to help us understand. Marcia, thanks for being here.
Pleasure.
So let's talk about the case today. It's about a Texas congressional and legislative map, right? The allegation was that it was challenged as racial gerrymandering. What did the court say today?
Well, the court divided 5-4 along ideological lines. Justice Alito, joined by 4 conservative justices, led the court in the majority opinion, and the majority rejected a lower court's findings that Texas had engaged in racial discrimination, primarily against Black and Hispanic voters, in its 2013 redistricting maps. Justice Alito said that the evidence of discrimination was insufficient to show that the Texas legislature, which drew the maps, had bad faith or had engaged in intentional discrimination.
I'm Denise Koch. A busy year of legal battles is getting underway over allegations that hundreds of legislative districts across the country were illegally drawn to disadvantage certain voters or political parties. First up is a court hearing Thursday in Virginia, where a federal judicial panel is reviewing proposals to redraw some state house districts that it determined were racially gerrymandered. Next on the schedule is a February trial in Michigan over allegations that U.S. House and state legislative districts were illegally gerrymandered to benefit Republicans. A similar lawsuit is on tap for March in Ohio. The U.S. Supreme Court also has agreed to hear arguments in March on separate cases appealing rulings of unconstitutional partisan gerrymandering of congressional districts by Republicans in North Carolina and Democrats in Maryland.
What is it you wanted me to reconcile myself to? I was born here almost 60 years ago. I'm not going to live another 60 years. You always told me it takes time. It has taken my father's time, my mother's time, my uncle's time, my brother's and my sister's time, my nieces and my nephew's time. How much time do you want for your progress?